I want to welcome all of you who are joining us on television in region number 5 and region number 6. Welcome to another program of Issues in the News. To those of you who are joining us on Freedom Radio from Rob Street, Georgetown, welcome to another program of Issues in the News. And last but not least, to the thousands of you who are joining us on Facebook Live right across the length and breadth of Guyana, the Caribbean, North America, Europe, Asia, the Middle East, and as far as Australia. Welcome to another program of Issues in the News. Share the live, share this program so that you and your friends and followers can join us in tonight's discussion. Use the comments section to voice your views, ask questions, raise queries, and invite me to discuss any issues which you wish to be discussed. Make the program interactive. Use the comment section to comment, and please share the live so that all your friends and all your followers can join us in tonight's discussion and we can have the widest possible audience. I see Nishad Sharma, Parmanand Suku, Robert Rampasad, Shahid Pepe Rahman, Ahmad Ali, John McIntosh, Narendra Sharma, James Fitzgerald, Penelope Harichan, Pamela Prasad, and so many of you, Thompson, Omar Dat Ragnat, and so many of you from all across North America, Guyana, the Caribbean, Europe, Brampton, Canada, and so many of you. Welcome, welcome, welcome. So, the Mohammed's new challenge in the High Court is what is the lead story tonight. They have filed, as you know, a proceeding in the High Court after the magistrate rejected their submissions. They moved to the High Court to file new proceedings, essentially canvassing the same questions which they canvassed before the magistrate and which the magistrate rejected as frivolous and vexatious. And they are asking the High Court, while that action is being determined, the action that they have filed to address these very questions that they asked the magistrate to determine, while that, what is called a substantive action, is waiting determination, the judge should grant a stay of proceedings, staying the hands of the magistrate until that substantive case is heard. Today, we had a hearing in relation to the stay application. Then there is another case that they have filed in the High Court. A date has not yet been fixed, I think. And in that case, they are also seeking another stay. But that one has not come up yet. The first case that they filed in the High Court came up and the stay application was heard today. Now, if you want to stay proceedings, obviously there are legal principles that govern the exercise of a court's power to grant a stay. You have to show, because the stay is an interlocutory relief, it's an interim relief, while we await the hearing and determination of your substantive action. So, in other words, you're asking the court, look, I have a case which will be heard later, but grant me this stay now to stop this magistrate until my substantive case comes up. Now, it is a high threshold to meet to get a stay in such circumstances. In extradition cases in particular, it's an even higher threshold. You first have to show that you have raised serious issues of law in your substantive case. That's the first thing. Then you have to show that unless this stay is granted, you will suffer irreparable harm and prejudice. And thirdly, that the balance of justice lies in the grant of the stay. In other words, greater prejudice will come to you, greater harm will come to you if the stay is refused vis-a-vis the other side, because a case always has two sides. In other words, the other side will suffer less harm, less prejudice than you would suffer if the stay is not granted. And those are the legal principles in a nutshell. And of course, these principles have been decided in many, many cases and how it should be approached. But the main issue is that you have to have serious issues that you have raised. A court will not grant a stay if your substantive case is weak and you have not raised any real issues. And in my submissions today, I argued that they have not raised any serious substantial issues. That the issues that they have raised are not serious, they are frivolous, they are vexatious, and they are without merit. Their main contention is that the amendments made to the Fugitive Offenders Act in 2009 are unconstitutional. 2009 is over 15 years ago. We have decided many cases already in relation to extradition law using those same amendments. Challenges have been filed against the legality and constitutionality of those very amendments, and those challenges have failed. And those cases are there. The issues, therefore, are not new. Today, we had to go through all the arguments. So they spoke first, I spoke second. And I went through section by section of the amendments that they are questioning. And I believe that I was able to clinically, clearly, and forensically establish to the court that they are misreading the amendments, they are misinterpreting the amendments, and that Parliament committed no error when Parliament amended the law. And Parliament amended the law because it was felt at one point in time the law was not clear because of divergent rulings. You had a Court of Appeal ruling and you had a full court ruling that said two different things. And in 2009, the then Attorney General decided that he will pass some amendments to clarify the position. Because you had a full court in a case filed by a man named Barry Dataram, which is a lower court to the Court of Appeal, refusing to follow decisions of the Court of Appeal, a higher court, on certain issues of law. And law is based upon precedent. The decisions of higher court bind decisions of lower court. So you had a lower court that refused to be bound by the higher court. So you had some kind of confusion, if one may use that word, in the state of the law. And the 2009 amendments were intended to cure that and to bring clarity and uniformity to the law. And when I went through the explanatory memorandum of the 2009 bill, and it explains very clearly the intent of the legislation. And I believe that I was able to show the judge, having gone through provision by provision of those amendments, that there is nothing wrong with it. You see, one may not like a particular provision. That does not mean that it is wrong. Parliament has the widest power to make laws for the peace and good governance of Guyana, subject to only one caveat, one conditionality. And that conditionality is that the law must comply with the Constitution. The law must not be inconsistent with the Constitution. The law must not violate, either by implication or expressly, any article of the Constitution. They have been unable to point to a specific article of the Constitution which the 2009 legislation is inconsistent with. Put another way, they have been unable to cite any provision of the Constitution that is violated or that is inconsistent with the provisions of the 2009 legislation. And once you are unable to do that, then the legislation stands. Parliament is free to legislate. Not because you don't like it or you think that it is unfair, means that it is wrong or it is illegal. The only basis that the judiciary has to strike down a law passed by the Parliament is if that law violates the Constitution, is contrary to the Constitution, or in some way is inconsistent with the Constitution. Other than that, Parliament is free to pass any laws. And Parliament passed some laws, made some amendments in 2009. These amendments have been scrutinized by judges before. As I said, they are 15 years old, and they have never been found to be unconstitutional. So the issues that have been raised in terms of the unconstitutionality of these legislation are not issues that have merit, and therefore right away the case falls. There is no basis to grant a stay. Secondly, no great prejudice can be suffered or no irreparable harm can be done, because if it is that you are complaining that the magistrate court must be stopped, because if the magistrate concludes the matter, you will be extradited. You have remedies that are available to you in the Fugitive Offenders Act that allow you to challenge the magistrate's ruling all the way up to the Caribbean Court of Justice. And at every stage of the challenge, the Fugitive Offenders Act itself provides that no steps can be taken to extradite while the proceedings are pending. And in those challenges, you are free to raise all issues that you have: unconstitutionality, illegality, lack of evidence. Everything can be raised there. Why try to preempt the magistrate from concluding when the law says the magistrate must conclude and then you must challenge? The law does not contemplate preemptive strikes. The law contemplates a linear movement of the case. And extradition matters are not trials. No one is charged. A person can't be found guilty in an extradition proceedings. It is not about determination of innocence or guilt. It is simply a process that one has to go through. It's part of international law. So the constitutional rights that you have to a fair trial, constitutional rights to liberty, constitutional right to freedom of movement, they don't necessarily apply to extradition proceedings in the same way that they apply to other proceedings. Extradition proceedings are what is called sui generis proceedings, meaning they are peculiar. They stand by themselves because you're going to be tried in a different country. That is where your trial will take place. And our Constitution, in relation to those very rights, right to liberty, right to fair trial, right to freedom of movement, it puts as an exception extradition and extradition proceedings. In other words, one doesn't have to guess whether the provisions apply. The provisions say that they do not apply. And international law says that it does not apply. What applies is the Fugitive Offenders Act and the whole hierarchy of challenges that it provides. And that is where persons who are the subject of extradition proceedings get their due process. But you have to allow the process to work. If not, what will happen? A high court challenge will come before the magistrate court determines the matter. Then someone is aggrieved by the high court challenge. They go to the Court of Appeal, and they are aggrieved by the Court of Appeal decision. They go to the Caribbean Court of Justice. Months or years may pass, and the magistrate is yet to conclude the extradition hearing. That could never be the policy of the law. That could never be the intent of the law. Extradition would be frustrated worldwide if these collateral challenges are allowed to take place. And that is why the authorities uniformly say almost across the globe that the challenges must be allowed, that the committal proceedings must conclude, and then you challenge all the way up. You can't have multiple challenges going on at the same time. The proceedings will never done, will never be completed. And I quoted a case from Canada that says that when a country can't complete its extradition processes and its international obligations to fight crime and to cooperate with other countries to fight crime, then Canada loses. The same principle applies to Guyana. If one is to allow extradition proceedings to be inundated with collateral challenges, tangential challenges, and the extradition itself is allowed to languish for years, then we will not be a reliable international partner in the crime fighting arena. And we would be failing our obligation as a state party to these international obligations and treaties. And it is against that backdrop that extradition law must be understood. And the extradition law is not the law of, it doesn't apply to Guyana alone. Extradition law is universal. The law of Guyana in relation to extradition closely resembles the law of almost every other country that has a legal system similar to ours in relation to extradition. It's a mixture of extradition, of municipal, domestic law, and international law. And you can't use domestic law or municipal law, as it is called, to frustrate the operation of international law. And these are concepts that have to be explained so that you understand the environment in which extradition law permeates, and you look at extradition law from the perspective that it ought to be looked at. And I hope that people understand that. So it's not that there are not going to be challenges. There are going to be challenges. But the challenges must be done in the manner set out in the law. Not in a disruptive way, to disrupt the magistrate's court. If they are discharged at the end of the committal proceedings, the state has a right to appeal, to challenge the magistrate. If they are committed, they have a right to challenge. So, and both sides have appeals going up. And there is no limitation, importantly, in those challenges in relation to what you can argue. You can argue every single thing. What you think they will argue in the, let us say the persons are committed. Meaning that the magistrate has found that they should be extradited. And they start the process that the act allows them to do, challenge upwards. It is the very arguments that they are arguing now in the High Court. They will replicate again. They will duplicate again. That is a classic case of abuse of process. Saying the same thing over and over again in different courts. That is an abuse of the court process. And that, in short, was my submission, supported by case law authorities. The judge has fixed the matter for ruling on the 5th of January. That is next Monday at 11 a.m. So let's see how that unfolds. And I've said repeatedly, one of the subject persons, they are offended when I say fugitive offender. But that is how the law describes them. One of the fugitive offenders have said publicly, and you heard him, that these proceedings will take 5 years. And I said it pointedly to the court, that these legal forays into the Constitution And this application for stay of the magistrate court proceedings are all intended to carry out that manifest confession that there is an intent to delay the proceedings beyond 5 years or for 5 years. That is what these are intended to do. And every court has a duty to guard itself against abuse. The law on that is very clear. Courts should not allow multiple challenges of the same type when the law outlines a specified method of challenge. It is called a fishing expedition, hoping that something will stick. So we will know Monday how the court rules. And as I said, there's another challenge when this one is completed. This is only the stay. There is a substantive challenge to this. And then they have filed another challenge. A date has not been fixed for that one yet. And that one has a stay too. An application for a stay. So we have to go through this process again. Now tell me, if that is not, these proceedings are not intended to delay and protract the extradition proceedings. If they are innocent, go and do what you got to do. Defend yourself. It's as simple as that. Why this great resistance? So it would not be in the interest of justice for the magistrate to be stopped from proceeding to perform or statutory function of proceeding with the committal proceedings. That is what the law says the magistrate must do. And perhaps in the rarest and most exceptional circumstances, should that magistrate be stopped from performing her statutory functions. So that's where I'll put that issue and leave it there. I've said a lot about it, and you will see more in the news because I spoke to the press after the hearing was concluded. But I already spent a lot of time on it already here. You will recall in the President's address to the nation earlier this month at the convention, the Artachon Convention Center, he spoke about the launch of the revised laws of Guyana and the Guyana law reports. I am pleased to report that the launch of the revised laws of Guyana and the Guyana law reports will take place on Wednesday, January the 14th. Wednesday, January the 14th. Revision of laws is the process whereby all the amendments that have been made to principal legislation and all the new laws are consolidated into volumes and published one time as the laws of the country, as of a particular date. The date here will be the laws are revised as of the 31st of December 2021. The last time we did law revision was in 2012. Coincidentally, I was the Attorney General again. We did the revision of the laws of Guyana Then, on that occasion, the law revision exercise extended as far back as 1977, because since 1977 we never revised the laws of this country until 2012. So you had a large volume of laws to revise, to bring in all the amendments, find them, bring them together, insert them into the principal law, and then put all the new laws together, renumbering them. And when that process is completed, it's called revised, the revised laws of Guyana. So the last time we did that was 2012. We are doing it up to December 31st, 2021. And that is what we are launching. The law reports now, and you have been hearing a lot about doctrine of precedent. Judges decide cases, and the decisions of these judges guide future decisions for there to be uniformity and consistency in judicial decision making. And as a fundamental principle of the rule of law, a society must have judges who make decisions consistently and who follow existing judicial decision. It is called the doctrine of precedent. And the court system is structured in such a way that the higher the court, the decisions of the higher court binds the decision of the lower court. And that is why the magistrate in this Mohammed's case said that I am bound by Court of Appeal decisions. I can't depart from it. She was referring to the doctrine of precedent, or the principle of stare decisis, which says that the decisions of higher court bind lower courts on the same issues of law and facts. When each country put their cases together in volumes, and they are called law reports, so that judges, lawyers, and litigants, if they wish, can have easy access to cases when they want to research a particular issue. And that is why it is important that these cases be accumulated, consolidated, and put into volumes by subject matter and by year. The last time we printed law reports, again, was in 2012. On that occasion, we published law reports from 1977 to 2007. Now we are going to do from 2008 to 2021. So a case decided in 2016, you can go to the an important case, because only important cases are reported. Cases are determined every day. Not all are worthy of reporting. Cases that determines important principles of law are recorded and reported to guide future decisions on similar issues of law. Again, this is an important aspect of the legal architecture of a country. And countries all over the world compile their law reports for this particular purpose, because there must be certainty in the law. And as soon as we launch this up to 2021, December, we will begin a process to start to compile from 2022 to the next set of years. That process has already begun. And this has to be a continuous exercise. And this is the responsibility of the Attorney General Chambers. And I am pleased to announce that we have completed these landmark achievements. And these are not ordinary achievements. They are very tedious work, complicated work, time consuming work, and they cost a lot of money because it's important that the laws of a country are in one place, are easily accessible, and that the case law of a country is also equally accessible and in a centralized place. That is the cornerstone of these initiatives which we will launch very shortly on the 14th of January. So I'm looking at your comments, and there is some debate going on as to who is confused, and I will not trouble you. You continue to have healthy debates. I have no problem with that. I don't want any abuse, any indecent language, and racial slurs and allegations. I'm going to ban or block people who do that. I've said that openly. No racism, no indecent language on the comments. Next week also, the president will head the distribution of 125 titles to residents of Cotton Tree. Recall we started this process several years ago, and we have been doing it in tranches. It's several villages on the west coast of Berbice that we are regularizing. This is where the government is spending millions and millions of dollars at no cost to the residents in order to give them certificates of title for lands that they have been living on for generations. And 125 families will receive titles come January the 9th at the Cotton Tree Community Center, West Coast, Berbice. And this is a joint effort led by the Attorney General Chambers again, the Land Registry, Lands and Surveys, and the Lands and Surveys Commission, and the Commissioner of Title or Land Court Judge in Berbice. We suffered a great delay because we didn't have land court judges at the time. Once we got the judges appointed, the process has resumed. And our government is going to aggressively continue the land regularization program across this country. President Ali has been authorizing the Attorney General to continue this process, and in 2026 that process is going to continue with even greater aggression. In fact, a title section, a title regularization unit is being established within the Attorney General Chambers to dedicatedly deal with these issues. And thousands of persons, hundreds of families will get title for lands that they have been living on for generations at no cost to them. I don't think that there is any other government in the Caribbean that's undertaking such an initiative at this magnitude. As I said, several villages on the west coast of Berbice are being targeted. Villages on the Essequibo coast are subject of land regularization exercises. Villages on the quarantine are subject to similar land regularization exercises. And you will see in due course when we start to distribute the titles. As I said, it's very tedious work, but it's all for the benefit of the communities and the people of our country. Title to land is economic power. It's empowerment. You know, a lot of people speak about empowering people and empowerment. But let them show you what they have done for real empowerment. And look at the PPP's track record on these issues. Look at the housing sector. And then look at my small unit and what it has generated in terms of empowering people with real economic power. Not propaganda and utterances, but giving them kagaj, the lawful title to land. That is what empowerment is. And that's what we are doing right across this country. I am happy that the Commonwealth Observer Mission, another observer group that observed the September 1st elections, that group came out with its report, and again it certified the September 1st elections to be free and fair, and it debunks the allegations concerning electoral manipulation in respect of the voters list. You know, that's a constant mantra being chanted by the opposition. And the observer team, recognizing the peculiarities of our law, the high density of our diaspora population, our constitutional realities, the provisions of the National Registration Act, and the Representation of the People Act, and concluded that these allegations of a bloated list and that the list is being manipulated for electoral gains are completely unsubstantiated allegations. That is what the report found. And as I am on this topic, many of you don't know, but I invite you to look at the official gazette of the 15th of December 2025. And that's why we put the gazette online, you know. All of you, you're on social media, you are using your internet for all types of purposes. Use your computer and your devices for useful purposes as well. And go and look at the official gazette online. We put it online so that you can read it wherever you are, at your own convenience. And it has a lot of materials, but what I'm referring to is the official gazette of 15th of December 2025, where an order is published under the hand of the chairman of the Guyana Elections Commission, informing the public that the claims and objections process has begun and is ongoing. And it details the centers where you can go right across the length and breadth of Guyana. The order specifies the period during which this process will take place. And by law, this happens twice per year, every year, every 6 months. It happens. It's happening now, and it will happen in June, and then it will happen in December again, 2026. This is the period, this is the process rather, that allows the opposition to go to all the offices of GCOM stipulated in the publication in the Gazette, and this is also published in the newspapers. I saw it last Sunday. To go to the offices and register their objections of the bloat on the list. Go take the people, go to the registration offices with your claims and your objections. I am calling on all those opposition politicians and their supporters who are speaking about a bloated list. Now is the time for you to go to a GCOM registration center and identify the bloat in this claim and objection period. If there is a bloat, if there is an illegality, go now and object to it. And a process will be triggered to remove it. According to the PNC, there are thousands of people who should not be on the list, but are on the list. Now is the time to go with that, your 1,000 persons, or the thousands of persons, and get them removed from the list. They will not do that. They will not even go and file one objection or make one claim. But whenever the occasion presents itself, they will parrot the rhetoric that the voters' list is bloated. That has been their mantra. They will robotically repeat, the voters' list is bloated, and they want house-to-house registration. When we have repeatedly said that we have a continuous cycle of registration that is ongoing, and that is the antithesis of house-to-house registration. So I'm calling on the PNC and I'm calling on the Win Party and every other person who have been alleging publicly that the list is bloated, go now with the thousands of objections or the hundreds of objections that you have and register it now at one of the registration offices of GCOM. And they are listed here, right across the country, from regions 1 to 10. It's in a schedule. None of them will go. None of them will go. And I'm happy that the election observer group reports are in the news. Because I want those same observers to hear me call upon the opposition who complain to them about a bloated voters list, to hear me call upon them to go and remove the bloat now. And they get an opportunity twice per year to do that. But they don't do that. They don't do any of it. But they will come back and repeat slavishly. They will repeat slavishly this unfounded rhetoric about a bloated voters list. You will recall that the President, in his address, after consulting with the judiciary, disclosed that the judiciary has successfully tackled, by and large, the backlog of cases that have burdened the High Court for decades. But that there is now a backlog at the Court of Appeal. Last week, another Justice of Appeal took the oath of office. The Honorable Justice of Appeal Rafiq Khan, Senior Counsel, took the oath of office before President Ali. Justice of Appeals Khan's addition to the complement now puts in office a sufficient number of Court of Appeal judges for us to have 3 complements of 3 judges each, which is the normal quorum of the Court of Appeal. And with 3 complements, you can have 3 courts sitting. And I believe that this measure can go a far way in tackling successfully the accumulated backlog in the Court of Appeal. Today, a former client of mine visited me from Canada. His mother's appeal is pending since 2015 in the Court of Appeal. 10 years have elapsed, and the appeal has not yet been fixed for hearing. 10 years. One side in the litigation has already died. That is what happens when delay afflicts the system. So while we have addressed it after years of hard work in the High Court, I am hoping that we can alleviate the backlog accumulated in the Court of Appeal with some alacrity. And the judiciary has expressed their commitment to do so. And the government of Guyana will support them fully in the pursuit of that objective. And as I said, you will have 3 sets. The Court of Appeal normally sits with 3 judges sitting together as a quorum. So if you have, I think you have 10 judges there now. So you will have 3 sets of 3. So there should be much alacrity now in relation to the hearing and disposal of appeals. The tint regulations, I see our Minister of Home Affairs has adjusted the regulations, and that was predictable because what was quoted in the initial disclosure as the manufacturer's tint was not the standard, the actual standard of the manufacturer's tint. Well, different manufacturers have different standards. It's extremely difficult, if not impossible, to get all manufacturers to produce tint at one level. So with an acceptable variable or variation, the new publications now, I believe, accurately, as far as possible, captures what the policy position is, which is, as far as possible, to maintain manufacturer's tint. And the minister has disclosed the particulars of the policy. There is no need for me to regurgitate that here, except to say that now that the policy is settled, we will now move to make it the subject of regulation. And that will be done shortly, and it will become part of the Road Traffic Act and regulations made thereunder. And you will have the relevant fines and penalties, etc., elucidated in those regulations to cater for violations of the regulations. The regulations, as you know, are law, so they are enforceable as law. And that will be done shortly and will be published in the official gazette as is required by law and laid in the National Assembly of our country. I see Juman Yassin has penned a letter in Starbrook News asking for a friendly debate. I read the letter and I don't see anything to reply to. I'm not. I reply to the press when I believe the matter deserves a reply. There are certain matters that I believe do not deserve replies, and I will not reply to them. You know, as my grandmother used to say, you don't run to everything in Cobra Knack. You know, time is precious, and my energy is also limited. So we have to use them economically. This would be the last program of 2025. We have concluded another year. We have concluded a decade of issues in the news. And I want to congratulate all of you for staying faithful to me over this year and many years prior to this year. And I know some of you have been watching this program from the inception. And to you, the 10-year-olds, I want to specifically and specially congratulate you for your longevity and the decade of support that you have rendered to this program. And to all of you, please continue to join us every Tuesday. We will continue into the next year, and the program will run as long as possible. As I said, we are going to make some changes. We may have call-ins, we may have guests. I will be moving to a newer studio shortly. You will be informed of it, you will see it, and we'll have a little more sophistication. My operator likes sophisticated equipment, so we have some new equipment which we'll be using in about a week or two from now, and you will see the difference in quality. So we are still in the middle of the festive season. I take it that you have enjoyed the first half. You have enjoyed your Christmas, your Boxing Day, your Christmas Eve. You have survived. I hope you have not overdone anything. And we are moving into the second half of the festive season. Tomorrow is All Ears Night. Tomorrow you have parties and fetes all over the country. Stay safe, enjoy, but ensure that you do not abuse. And I want to take this opportunity to wish each and every one of you a happy, prosperous, and healthy 2026. We have an exciting year ahead. Join me during the course of next year. Continue to join me as we continue to have this important discussion every Tuesday night. Thank you very much. Take care and best wishes for the new year. May God continue to bless you. Thank you.